This hearing of the Senate Judiciary Committee will come to order. I'd like to take a moment to first acknowledge that this is our first full committee hearing since the passing of our friend and colleague, Senator Dianne Feinstein, a treasured leader of the Senate and this committee. It is a bit unreal to begin these proceedings and to know that our dear friend will not be joining us at the dais. Dianne conducted herself with steely determination, grace, and dignity in all of her work before this body, and I hope we will all try to honor her by measuring up to that high standard. I want members to know we're working on a plan to honor her personally for her service on the committee, and we'll talk about that a little later. Today we'll hear from 5 judicial nominees. Judge Mustafa Khoshubai, did I come close to pronouncing that correctly? Good. Nominated to the District of Oregon. Judge John Kazin, nominated to the Southern District of Texas. Judge Shanlon Park, nominated to the District of Hawaii. Jamel Semper, nominated to the District of New Jersey. And Micah Smith, also nominated to the District of Hawaii. Congratulations to each nominee and your family and friends who gathered. Before I turn to Ranking Member Graham, I want to note that each of today's nominees has received blue slips from both home state senators. This includes Judge Kazin, who has received blue slips from Senators Cornyn and Cruz. Both senators previously worked with the White House on the nomination of Judge Irma Ramirez to the Fifth Circuit, and I thank them and the White House for continuing to work in good faith to fill judicial vacancies on Texas district courts. I look forward to similar progress in other states. We have several colleagues joining us to introduce nominees today. And first, I'll turn to Senator Graham for any opening remarks.
Thank you, Mr. Chairman. I think all of us on this side have the same view of Senator Feinstein as you do. She was a consequential senator, an incredibly kind, decent person who was passionate about her causes, but you could always find common ground if you sought it with Dianne. And she will certainly be missed. If you're looking for a role model as a young person, how to conduct yourself, I would recommend Senator Feinstein. The life she lived would be a good one to try to replicate. So a couple things. Last month was the largest illegal crossings, I think, ever. Border is in absolute chaos. Ukraine, since the war started, that was supposed to last 2 weeks, has destroyed 50% of the Russian combat capability. We spent less than 5% of our military budget in helping Ukraine, and NATO is larger. So if you told me in the 80s not one American soldier would have to die to reduce the combat capability of the Russian military, and you could do that for 5% of our military budget, nobody would have believed you. Ukraine has taken back 50% of the territory lost in the initial invasion, and back from 2014 even. What more do you expect these people to do? They're fighting like tigers. They have died by the thousands. It is in our interest. To those in the Democratic side, we have to come up with a border security plan that will stop the flow. 8,000 to 10,000 people a day with no end in sight is unsustainable. The asylum system is broken. The first safe country rule has been ignored. Parole has been abused. I will challenge my Democratic colleagues to work with us to find a strong border plan to stop what is going on at the border. To my Republican colleagues, I don't know how the drama in the House ends, but I want us to be the party that recognizes you do not solve your national debt problems by reducing the power of your military in dangerous times. It's never cheaper to let people take land of others by force of arms because they won't stop. So if you're worried about adding to the debt, let's make sure we don't have a major war between NATO and Russia, and that China is not enticed to invade Taiwan. Being strong is cheaper than being weak. And if you really want to do something about the debt, which we all do, most of the money is not in the discretionary accounts. So with that, Mr. Chairman, I'm ready for the hearing.
Thank you, Senator Graham. Let me just say that I couldn't agree with you more in your statements on Ukraine. I was saddened, angered, maybe even embarrassed that we did not include money for Ukraine in the recent continuing resolution. The war goes on. The Ukrainians are sacrificing their lives. As the president of Ukraine, Zelensky, told us when he met with us just a few weeks ago, we give our lives, we ask you to give your money. That's not too high a price to pay to defend freedom and democracy in this important part of the world. And I stand ready and hope that we do this quickly. On the issue of the border, I have said it publicly before, and we are struggling to find a starting date, but I hope it's soon, when we do sit down on a bipartisan basis and start talking about the border. Congress has to accept its legislative responsibility. We cannot just point fingers at the White House. We are the ones who are commissioned to write the laws and to make the policy that the White House should follow. And we have a lot more to do. We haven't had a significant immigration bill for over 30 years. We need one and need it now. And I'm ready to join you on a bipartisan basis to make that happen. We have introductions for our nominees, and many of our colleagues are here for that purpose. And first up is Senator Ron Wyden of Oregon to introduce Judge
Kasubai.
Thank you.
Thank you, Mr. Chairman. Mr. Chairman, thank you very much for your courtesy and all your help with our nominee. And to colleagues, just one sentence about Senator Feinstein. Last night I was looking at pictures, and at an event that she organized, there was our former Republican leader here, Senator Cornyn Trent Lott, standing with Henry Waxman, the California liberal. And I said to myself, that was part of the beauty of Dianne Feinstein, always bringing people together. Remarkable. So Senator Merkley and I are very pleased to be able to join all of you to introduce Judge Mustafa Kasubai, nominee for the District Court for the District of Oregon. His credentials are so long I would keep you till breakfast if I went through, and I would ask Mr. Chairman if we could make my remarks part of the record, and I'll just make a couple of comments.
Without objection.
The judge is eminently qualified for this position. You've got those qualifications. He was a district court magistrate, so in effect he was the first Muslim American judge to be appointed to the federal bench. And he's been in private practice, and I think for my first point, because a number of you have raised it, Senator Merkley and I hold town hall meetings in all of our rural counties, have some this weekend. The judge has extraordinary rural credentials because before he served as a magistrate judge, he practiced law in Klamath Falls. Now, if you're not familiar with Klamath Falls, I got a town meeting there in a few days. It's very rural, agriculture, natural resources, and it's a place that's recruiting doctors and lawyers and the like. But to give you an idea of these kind of rural connections, the judge owns a portable sawmill that he uses to mill logs into beautiful finished wood products. So if you ever are looking for a way, Senator Whitehouse, to have some wonderful floors in your home, don't call Ghostbusters, call our nominee because he can do it for you. So he is the first South Asian American to serve on our local courts at home. When he was appointed as magistrate judge, as I said, he was first Muslim American. In his 60 years on the bench, he won awards for judicial excellence from the Oregon Bar, the National Asian Pacific American Bar Association, and they are a testament to his work ethic and his expertise. The unanimous judgment of the American Bar Association was to rate him as well qualified. And one of the other areas that Senator Merkley and I appreciate about the judge is he's always mentoring students in order to create hope and opportunity for the next generation of legal professionals. Mr. Chairman, I've entered with your staff the letters of support from across the political spectrum, across Oregon, across this country, people who have worked with him. I urge all members of this committee to support Judge Mustafa Kasubai, and we'll be happy as Oregon's United States senators to work with all of you for those who want additional information. But I know some of you asked questions about the judge's connection to rural communities, and his are stellar. Thank you, Mr. Chairman.
Thanks, Senator Wyden. Senator Merkley.
Well, I am honored and pleased to add my voice to that of my colleague, Senator Wyden, in support of this nomination. Mustafa Kasubai's leadership in the law has been evident since he first came to our state over 30 years ago as a young man to attend the University of Oregon School of Law, and he served as president of the Student Bar Association. Soon after, he began his career in private practice, representing clients throughout southern and eastern Oregon while working out of offices in Eugene and Klamath Falls. It gave him a personal understanding of the challenges facing working folks living in rural areas, which can look very different in our state, as in so many states, from the viewpoints in larger cities. His service continued as a member of the Oregon Workers' Compensation Board. He was appointed to the Lane County Circuit Court in 2007, where he served for a decade. And that was when the Board of Judges, which is composed of the active and senior federal court judges for the District of Oregon, elected Judge Kasubhai to serve alongside them as a U.S. magistrate judge. He served in that position ever since, and in September, President Biden nominated him to join their ranks on the U.S. District Court for Oregon. I appreciate his quote when he said, "I have always imagined that democracy is solar-powered. It works when a light shines on all of its functions. That light is the rule of law." And earlier this week, he visited the National Archives to, in his words, pay tribute to the Constitution. So it's with admiration and with pride that I commend his nomination to all of you sitting here on the Judiciary Committee. Thank you for taking into account his sterling credentials, his breadth of service at all levels, and the respect and admiration of his peers and his students all across our state. He's an outspoken champion for justice, a fierce believer in democracy, and a passionate advocate for the rule of law. Thank you, Mr. Chairman, Mr. Ranking Member, and members of the committee.
Up next is Senator Cornyn to introduce Judge Kazin.
Thank you, Chairman Durbin, for allowing me to introduce John Kazin, who's been nominated for a vacancy in the Laredo Division of the Southern District of Texas. Since 2018, he's served as the U.S. Magistrate Judge on the District Court. He's handled over 85 civil consent cases that have gone to final judgment. As members of the committee know, magistrates ordinarily do not handle the full docket that a federal judge does, but in cases where the parties consent, then they can. So he's handled 85 civil consent cases gone to final judgment, as well as almost 2,000 misdemeanor cases. And it's unusual, at least my observation, that magistrates or that parties consent to magistrates to try jury trials. But he's had 7 civil trials and 1 misdemeanor criminal trial, which is a remarkably high number for a magistrate judge, particularly since he's only served since 2018. Judge Kazin has gotten high praise from the Laredo legal community and from the other district judges in Laredo. Judges Marmolejo and Saldana rave about his work. A good benchmark of this is that Judge Kazin has an overwhelmingly high number of consent cases, as I mentioned. That represents, I believe, a great vote of confidence in his integrity, his temperament, and his legal abilities. Prior to his current role, Judge Kazin spent the majority of his career in private practice, working at a firm he founded in 1997. It's significant that Judge Kazin has been nominated to this position because his father, George Kazin, a revered icon really in the legal community in Laredo and South Texas, served on the federal bench for 39 years. So I know, Judge, your father passed away in 2021, and I'm sad, as I know you are, he couldn't be here today to share in this remarkable accomplishment of yours, but it's clear that his legacy lives on. Senator Cruz and I, Mr. Chairman, and I appreciate the kind comments you made about our good faith cooperation with the nomination process. Senator Cruz and I, as you know, have a Federal Judicial Evaluation Committee. It's a bipartisan committee of some of the best lawyers in the state of Texas. We call it the FJEC for short, the Federal Judicial Evaluation Committee. It's an institution that I'm very proud of because we make sure, regardless of who's in the White House, that we have properly vetted candidates we can recommend to the White House. And we appreciate the fact that the White House has been receptive to our willingness to work in good faith. Senator Cruz, I know, feels the same way. And Judge Kazin received the highest marks of any of the people interviewed for this position. So I have a great deal of confidence that he, Judge Kazin, will faithfully uphold the rule of law and the Constitution of the United States, and I look forward to supporting his nomination, and I would urge all of my colleagues to do the same. Thank you very much.
Thank you, Senator Cornyn. We have two nominees from the state of Hawaii, and I will recognize the senior senator, Brian Schatz, first to introduce Judge Park and Mr. Smith.
Thank you very much. Chairman Durbin, Ranking Member Graham, members of the committee, I'm proud to support the nominations of Micah Smith and Judge Shanlin Park to serve as judges on the U.S. District Court in Hawaii. Both of them are exceptionally qualified, and I appreciate the opportunity to help to introduce them to the committee. Micah Smith's story is a quintessentially American one. The son of an immigrant, he grew up in a housing project on Kauai, attending public schools before going to Lock Haven University, where he graduated with top honors, and later to Harvard Law School. For the past 11 years, he has served as a federal prosecutor for the U.S. Attorney's Office, first in the renowned Southern District of New York, and more recently in the District of Hawaii, where he serves as Deputy Chief of the Criminal Division. Those who know him often highlight his abiding sense of fairness and balanced temperament. A colleague noted, quote, "He listens and considers carefully before voicing his opinion," adding that he has an unwavering commitment to achieve a better system of justice that provides access to justice for all. That same commitment to equal justice underpinned Judge Shanlin Park's 2 decades as a public defender, giving voice to those most in need. A graduate of the University of Hawaii's Richardson School of Law, she represented low-income defendants on a variety of complex cases, earning a reputation among colleagues and opposing counsel alike as a highly skilled, compassionate, and solutions-oriented attorney. And she brought her integrity and sound judgment to the bench since becoming a state court judge in 2021. In supporting her nomination, a former boss remarked, quote, "The law is more than a job for Shanlin," calling her a great ambassador for the law. Judge Park's credentials are impressive by any measure, but the historic nature of her nomination should not be lost on anyone. If confirmed, she would be the first Native Hawaiian woman to serve on the federal bench. Both nominees have the legal acumen as well as the character and temperament required to fulfill the duties of the United States District Court judge. It's for these reasons that I'm proud to work with a member of the Judiciary Committee and my partner in the Senate, Senator Hirono, in supporting their nominations to the federal bench. Thank you very much.
Thanks, Senator Schatz. Senator Hirono.
Thank you, Mr. Chairman. I'm glad to join my colleague Brian Schatz in supporting the 2 nominees from Hawaii. So thank you, Mr. Chairman and Ranking Member Graham, for holding this hearing for our 2 outstanding nominees, Micah Smith and Judge Shanlin Park. And I want to begin by welcoming their families and their friends and loved ones, including all those who got up really early this morning to watch these proceedings in Hawaii. So in introducing Judge Shanlin Park, she has been nominated to serve on the U.S. District Court of Hawaii. Judge Park was born and raised in Hawaii, where her distinguished career has been spent almost entirely in public service, inspired, no doubt, by her father's work as a longtime Honolulu police officer. She graduated cum laude from Chaminade University and the William S. Richardson School of Law, and she clerked for Magistrate Judge Francis Yamashita. Prior to her time on the bench, Judge Park served in the Federal Public Defender's Office for the District of Hawaii for 20 years. During her career, she represented numerous indigent clients before the U.S. District Court for the District of Hawaii and the Ninth Circuit. After leaving the Federal Defender's Office, she entered private practice, and even there, she demonstrated her commitment to serving her community, receiving special recognition from the District of Hawaii for providing pro bono services. In 2021, she was appointed to serve as a Hawaii Circuit Court judge, and as a judge, she has earned high marks from practitioners and litigants for her even-handed approach and well-reasoned decisions. Judge Park is held in high regard in the Hawaii legal community, as demonstrated by letters of support that the committee has received from the former U.S. Attorney Flo Nakakuni, Federal Defender Salia Kamagi, and a group of prosecutors at the Honolulu Department of the Prosecuting Attorney. National groups have also offered support for her, including the National Asian Pacific American Bar Association, the Native Hawaiian Bar Association, the National Congress of American Indians, the Native American Rights Fund, and the National Native American Bar Association. If confirmed, Judge Park would make history, as noted by my colleague, Senator Schatz, as the first Native Hawaiian woman to serve as a federal district court judge, and we say it's high time and long overdue. Along with Judge Park, I'm pleased to introduce Micah Smith, nominated to serve in the U.S. District Court for the District of Hawaii. Micah has an impressive legal career. After graduating from Lockheed Haven University summa cum laude and Harvard Law School magna cum laude, he clerked on the U.S. Court of Appeals for the Second Circuit for Judge Huido Calabresi, and then on the Supreme Court for Justice David Souter. Micah spent 4 years at O'Melveny and Myers, where he helped author a brief in U.S. versus Jones, a pivotal Fourth Amendment case before the Supreme Court, and Justice Scalia wrote the opinion for a unanimous Supreme Court, siding with Micah's client, Jones. He then became a federal prosecutor, a job he has held for the last 12 years. He began at U.S. Attorney's Office for the Southern District of New York, where he tried cases on racketeering, drug trafficking, fraud, money laundering, and murder for hire. He was promoted to deputy chief and then co-chief of the Violent and Organized Crime Unit, where he supervised approximately 20 prosecutors. Even with all his success, Micah never forgot where he came from. A proud son of Kauai and graduate of Kauai High School, Micah returned home to Hawaii in 2018 to join the U.S. Attorney's Office in Hawaii. He was promoted to deputy chief of the office's criminal division and serves as the criminal civil rights coordinator, working closely with the Civil Rights Division, law enforcement agencies, and other prosecutors to protect the rights of people in Hawaii. And last year, he was also named Chief of Appeals and Legal Strategy, responsible for reviewing and editing appellate briefs, providing advice to other prosecutors in his office. The quality of Micah's work is evident. He has won numerous awards in his time at the Department of Justice, including the Homeland Security Investigations New York Prosecutor of the Year Award and U.S. Attorney General's Award for Distinguished Service, and many others. The committee has received many letters supporting his nomination, including from national organizations. So I know that both of these nominees have the kind of experience, temperament, and demonstrated commitment to public service, along with their deep roots in Hawaii, which will make them excellent judges in the Hawaii District Court. And after today's hearing, I know that my colleagues will agree likewise, and I urge their swift consideration and confirmation. Thank you, Mr. Chairman.
Thank you very much, Senator Hirono, and now recognize Senator Menendez.
Thank you, Mr. Chairman. Chairman Durbin, Ranking Member Graham, and distinguished members of the committee. It's an honor to join in introducing an exceptionally well-qualified nominee for the U.S. District Court of New Jersey, Mr. Jamal Ken Semper. For more than 15 years, Mr. Semper has tirelessly sought justice for the residents who call New Jersey home. It is a central theme that runs throughout Mr. Semper's career, an unwavering commitment to the rule of law and to the communities the law is meant to protect. He began his career as an assistant prosecutor in Union County, handling a wide range of cases across the appellate, juvenile, and adult trial units. Then in Essex County, he went after carjackers and murderers, including the first prosecution of a homicide under New Jersey's domestic terrorism statute. In 2018, he was sworn in as an assistant United States attorney in Newark, climbing the ladder, and ultimately serving as chief of both the violent crime and organized crime units. Today is the deputy chief of the criminal division, a role where he is responsible for supervising all phases of criminal investigation and efforts. In each of these positions, Mr. Semper has demonstrated an unflinching fidelity to the rule of law and the role of precedent in pursuing cases. Time and time again, he has forged the essential balance between keeping New Jersey safe and building trust between residents and those who have sworn an oath to protect them. This community-focused approach has earned Mr. Semper plaudits from individuals and organizations representing diverse interests, especially those who advocate for communities of color in the Garden State. Consider the words of Reverend Ron Slaughter, the pastor of St. James AME Church in Newark, on the day of Mr. Semper's nomination. He said, quote, "Semper has touched all the bases, stayed connected to the community, remained patient. This is a great day for New Jersey, America, our judiciary, and my community." And I couldn't agree more. Mr. Semper's nomination not only furthers our collective goal of addressing judicial vacancies across our state and country, it also advances our efforts to diversify the federal branch. It brings us one step closer towards ensuring that our most hallowed institutions reflect the rich tapestry of America. As I said at the start, I'm truly honored to introduce him today. Why? Because for nearly 18 years, I've always taken my constitutional duty to provide advice and consent on judicial nominees seriously. It's one of the most solemn obligations as United States senators. I'm a firm believer that our independent judiciary must reflect the best of America's values and its citizens, which is why I can honestly say that Jamal Semper's relentless commitment to public service, combined with his temperament, intellect, and the trust he has built with New Jerseyans, is exactly what we look for in a federal judge. He will no doubt be an asset to New Jersey's federal bench. I encourage my colleagues to give him all due consideration at today's hearing and urge strong bipartisan support of the committee so that it can swiftly be confirmed to his rightful place in the District Court of New Jersey.
Thank you, Senator. Finally, Senator Booker is here to introduce Mr. Semper as well.
Thank you. It's an honor to join my senior senator in singing the praises of Jamal Semper Fi. It's just Semper, although he is always loyal. This guy is incredible. And I don't want to repeat the things that Senator Menendez has already said, but I do think he left out that this man is incredibly Jersey. How Jersey is he, do you ask? He is a graduate of Rutgers Law School. He is a native son of Essex County. He is more Jersey than the Garden State Parkway, and he, like many people who have driven that notable road, has paid it forward. He's paid his tolls. And I will tell you, perhaps one of the greatest contributions he has made to our state, before I talk about his professional life, is his extraordinary family. Now, I just would love my colleagues to see this family, and I would ask them to stand up right now. It's not a commandment from the Senate, but it is a request. These are 4 incredible kids who I think are future leaders. I'm happy that the Constitution says they have to wait until they're 30 to run against me. But it is just an extraordinary family that he has, perhaps his best life contribution. But I live in Newark, where this man has worked for a very long time. He worked, and my Republican colleagues want to note, under a Trump-appointed U.S. attorney. And that work that they did, they sat together with my police director then in Newark, named Anthony Ambrose, and they came up with a strategy to keep our city safe. At a time that shootings were going up in a lot of places, the nominee will know that shootings dropped dramatically in the city of Newark because of their prosecutorial strategies. When I asked the mayor, when I asked the police director, what was one of the key secrets, they pointed to the work that this team did, and Mr. Semper was a major part of that. What does it mean when you have a city that drops in homicides or shootings almost a quarter? Well, it means that the city thrives. This is an extraordinary American in so many ways. In the prosecutor's office, he supervised 36 federal prosecutors in all phases of criminal investigation and litigation, helping to drive down crime in our state. In his current role as deputy chief, he also supervises Violent Crime Initiative, a joint task force that set out to reduce gun violence in New Jersey communities, and they had incredible success. I don't want to repeat all of his incredible credentials, but I do want to say something very personal. As many people on this committee know, that I am very concerned about how many people have been chewed up by the criminal justice system. We have a nation that has a proclamation that we are the free nation, but we incarcerate more people than any other nation on the planet Earth. There are more African Americans incarcerated today and under criminal supervision than all the slaves in 1860. And so I asked him in my interview, you're a prosecutor. You helped keep my city safe, but how am I sure that young men and women coming before you will get a fair shake at the criminal justice system? And in a very emotional response, He told me what many black men in America have, that the criminal justice system has visited upon his family. He's had a close family member who was a defendant. He brings something to the bench that we really need: extraordinary empathy. He's helped keep black communities like the one I live in safer and stronger. He's done it with empathy and heart. He has brought justice to this justice system. And should we give this great Jersey boy a chance to sit on the bench, as he showed with a U.S. attorney nominated by Trump, as he showed with a city that is a bright blue city in our nation, that he will find balance, he will find judicial restraint, he will find aggressive pursuit of justice, he will be the kind of judge that we need in the United States of America. And I know that this is a day that our ancestors are happy, that our bench in New Jersey should further reflect the experiences of so many people. This is a Jersey boy that I'm sure that will even make my friend from Louisiana, Senator Kennedy, proud. Thank you.
Thank you, Senator Booker. I thank all the members for coming and introducing the nominees who will now approach the witness table. Please remain standing. Thank you. Please raise your right hand. Do you affirm the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record reflect that all of the nominees answered in the affirmative, so we will let them proceed. And I'm going to start with Judge Kasuvai. With a 5-minute opening statement. The same opportunity will be given to each nominee. Judge, proceed, please.
Thank you, Chair Durbin and Ranking Member Graham, for the privilege of appearing before this committee for your consideration. I'd like to express my deep gratitude to President Biden for nominating me and for giving me a chance to serve my country. And to my home state senators, thank you, Senators Wyden and Senator Merkley, for those gracious introductions and for your strong support. Coming here 3,000 miles away, you brought a heart of Oregon that made me feel right at home. Now, I'd like to acknowledge some important people who brought me into this life and some people who give my life and work deep meaning. I'm the proud son of immigrants, Taher and Nafisa Kasubay. They immigrated here as Indian Muslims and soon after embraced their new identity as American Muslims. And in raising me in our faith traditions, I learned the importance of justice and mercy, kindness and compassion, and pursuing one of the highest callings, public service, and that to be in service to others requires practicing humility every day. And to my wife and best friend, Kristen, it is from our seemingly very different backgrounds that we've created a life together that's best summed up as a life of and, the most powerful word in the universe. And when bringing all of each of us into the mix, our sum is infinitely greater than the parts, and I love you to infinity and back. And to our 2 children, I am in awe of your beautiful and independent spirits. You both are an antidote to cynicism. You make me an optimist. And I love you both 2 times, to infinity and back, which makes 3 times to infinity and back a real number. To Bonnie and Ernie, my mother and father-in-law, you are the salt of the earth, and thank you for welcoming me into your home. You bring an abundance of humility and enduring commitment to family, and you've taught me that whatever we build it for centuries to come. In other words, you can't go wrong with adding more concrete. And to my friends and colleagues in the District of Oregon, I couldn't hope to work with more kind and gracious public servants. You embody that ideal of service to others. You make me a better judge. And finally, I'd like to thank my alma mater, the University of Oregon School of Law, the only public law school in Oregon and whose mission is to inspire public service. Thank you to all the deans and faculty through the decades who have inspired so many graduates, including me, to make public service our vocation. Honorable senators of the committee, I look forward to our discussion.
Thank you, Judge. Judge Kazin.
Chair Durbin, Ranking Member Graham, thank you for scheduling today's hearing. It is a privilege to appear before this committee. Thank you, Senator Cornyn, for your very kind introduction. I want to sincerely thank Senator Cornyn and Senator Cruz as my home state senators for your support and recommendation for me for this position. And of course, I want to thank President Biden for nominating me to the position of District Court Judge. I would not be here if it were not for the examples that my parents, Barbara and George Kazin, set for me throughout my life. My mother, Barbara, dedicated her life to serving the community and to helping the less fortunate of our community. My father was, to me, the embodiment of dedication and public service to the law. Although they have both now passed, they have given me their spiritual strength throughout this process. I'd like to introduce my wife, Haley, who is here with me today, who has always been a source of inspiration and strength to me throughout our 30 years of marriage. We are very proud of our daughter, Claire, who is finishing her last year of veterinary school and who could not miss the days to travel here because she's in the midst of her rotations. And so we're sad to miss her, but we are very proud of her. Here instead is one of our nieces, Miss Mia Escobedo, who is a political science major at Texas State University. She was able to take a few days off from college and join us. She was interested in this very constitutional process. There are so many family and friends and court staff and current and former law clerks who are watching and who have been incredibly supportive to me throughout this process, and I want to thank all of them from the bottom of my heart. I would also not be here without the mentors that I've had throughout my legal career. There is, of course, my father, but also Judge Robert Parker, who I clerked for after graduating from law school, the lawyers, many lawyers that taught and trained me at Kemp Smith Law Firm in El Paso, Texas, my former law partners in Laredo, and so many other lawyers and judges that I've learned from over the course of my career. But I particularly want to recognize the two district judges at our federal courthouse in Laredo, Judge Diana Saldana and Judge Marina Garcia Marmolejo, who have been mentors and role models to me during the past 5 years that I have worked with them as a magistrate judge. They have been tremendously supportive to me throughout this process, and I appreciate their guidance and mentorship. Senators, I look forward to answering your questions.
Mr. Chairman, I didn't know, he pointed out his wife, and his wife did not identify herself. I don't know if she's, there she is. Okay, so good to see your family here.
Thank you, Senator Booker. Judge Park.
Aloha, good morning, Chair Durbin, Ranking Member Graham, and members of the committee. I am grateful and humbled to appear before you this morning as you consider my nomination. I'd like to thank President Biden for the honor of this nomination, and I'd like to thank Senator Hirono and Senator Schatz for their very kind words this morning and for their recommendation to the President. I would like to take a moment to introduce a few important people in my life. First, my husband, Ku'uhaku Park, who has been with me for the last 28 years. His love and support, I couldn't do it without him. Next, my parents, Louis and Barbara Souza. My parents' support, love, and foundation have always been with me. They could not travel here with me today, and I hope they figured out how to use the link that I sent them so that they can be watching at 4:30 in the morning in Hawaii. I'd like to acknowledge and thank my two wonderful children, Kamalu and Kahiao. Being their mother has been an honor, and I am so proud of the people that they have become. I come from a large family and have many supportive friends. I won't go through that list today, but I do want to thank and acknowledge them as well. I especially want to thank Judge Leslie Kobayashi. If I am fortunate to be confirmed, I would be humbled and honored to fill her vacancy. Judge Kobayashi has been my mentor, my friend, my inspiration. She is the type of judge who leads by example and administers justice fairly and impartially and embodies the word aloha. I also want to acknowledge friends and colleagues spanning my 25-plus year career. These lawyers and the legal staff that I worked with embody hard work, integrity, kindness, and I have learned so much from them each and every day. Finally, I want to acknowledge and thank my state court family. I am so incredibly grateful to my colleagues on the State of Hawaii Judiciary, especially Judges Trish Morikawa, Lisa Cataldo, Rowena Somerville, and Jeanette Castanetti. My colleagues are good individuals who do good work to make Hawaii better, and I am proud to serve the people of Hawaii beside me. And finally, I'd like to thank my hardworking staff, Krista Odom and Trevor Tomashiro, as well as my past and present law clerks. These individuals allow me to do my job daily, and they have made my chambers a vibrant second home. Thank you again for the opportunity to appear before you today, and I look forward to your questions.
Thank you, Judge. Mr. Semper?
Thank you, Chairman Durbin and Ranking Member Graham, for scheduling this hearing. I'd like to thank President Biden for the honor of this nomination. I'd like to thank Senators Menendez and Senator Booker for your recommending me to the President, and as long with your kind words this morning. For 15 years, I've dedicated my career to public service by upholding the rule of law. I've been blessed to serve with selfless public servants. I'd like to thank my former colleagues at the Union County and Essex County Prosecutor's Office. I would like to thank all my state and federal law enforcement partners and all of my colleagues at the United States Attorney's Office in the District of New Jersey. I'd like to thank my friend and mentor, New Jersey's former U.S. Attorney Craig Carpenito, who first gave me the honor of serving my country 5 years ago. With me today is my mother, Judy Wilson, an immigrant from Guyana, who came to America after her mother, who served as a house aide to a family in New York, emigrated my mother to Brooklyn, where our American story began. Also with me today is my big brother, Khalid Alexander Semper, a September 11th cancer survivor who helped put me through law school. Also with me today is my life partner, my wife, Lucinda Jordan McLaughlin. We met 15 years ago while serving as prosecutors. We never imagined that our journey would bring us before this committee. We are blessed to be here today with our 4 children who are the absolute center of our lives and who I hope will be quiet during the course of this hearing. I would like to thank my father, Edrich Ken Semper, who we lost 5 years ago after a long and brave battle with cancer. While serving as a police officer in his native Trinidad, my father came to America with the hope of becoming a forensic scientist so he could return home to serve. The vast opportunities he received in America led him to become an engineer and a small business owner in New Jersey for 30 years. My father infused us with a love for America and a passion to serve others. I'm very grateful to him, and I look forward to answering your questions.
Thank you, Mr. Semper. Mr. Smith?
Chair Durbin, Ranking Member Graham, and members of the committee, thank you for considering my nomination today. Thank you to Senator Schatz and Senator Hirono for their generous introductions this morning and for their strong support. Thank you to their Judicial Selection Committee for recommending me to the senators, and thank you to President Biden for the tremendous honor of this nomination. It's especially an honor to be considered for the seat held by Judge Seabright, a fair and thoughtful judge and a dedicated public servant. I wouldn't be here today without the love and support of my family and friends, and so I'm grateful for the opportunity to introduce some of them to you today. My parents, Betty and Bill, flew in from Texas to be here. My mother grew up in what was at that time the territory of Hawaii in plantation housing. My father grew up in Central America, in Honduras, and he immigrated to the United States as a young adult. And through their sacrifices and hard work, they made it possible for their 4 children to have a better life. And one of their children is sitting before this honorable committee today. I thank my parents, and I thank our great country for making stories like ours possible. My wife, Tiana, is also here. Tiana and I grew up together on the island of Kauai. It's a small, tight-knit rural community. And for the last 20 years, I've been blessed with her optimism, humor, and love. Tiana is accompanied today by our 10-year-old son and our 7-year-old daughter. And like Mr. Semper, I'm very hopeful they'll sit still during the hearing. And we're so proud to be their parents. My siblings are all here as well. My big sister, Anna, my big brother, Luke, and my younger brother, Jonathan. They are quite simply the best siblings anyone could possibly have. And lastly, I'd like to thank my professional family. I won't mention everyone by name, but I would like to mention Justice David Souter and Judge Guido Calabresi, whom I had the honor of clerking for early in my career, Chief Judge Sri Srinivasan, whom I had the privilege of working with at the law firm of O'Melveny and Myers. I'd also like to thank my fellow law clerks from those years and my colleagues from those years, as well as my many friends from the U.S. Attorney's offices in the District of Hawaii and the Southern District of New York. Two of those friends, Ryan Piscablo and Robert Boone, were able to join me at this hearing as well. So thank you again, Senators, and I look forward to your questions.
Thank you. Each member of the panel will have 5 minutes of questioning. Judge Kazin, you presided over several naturalization ceremonies, including 2 this year. In one of your addresses to our new citizens, you said, and I quote, "Your journey is not over. America is a country of immigrants. America has been made great by immigrants. We are all children of immigrants." That was a very poignant and profound statement, particularly in light of the gathering today. We have so many people aspiring to serve this nation whose stories are stories of immigrants coming to this country at great sacrifice to be part of America. So are there any other observations you'd like to make about your naturalization experience?
Senator, I talk to the participants in the ceremony that I am the product of immigrants. I'm a 4th generation Lebanese immigrant. My great-grandparents immigrated from Lebanon. And so I share with them the example that my grandfather and my father and what they accomplished and what their children is what I mean of their story has not ended. Their children and their descendants will contribute and have the potential to contribute to this country and enrich this country. And so the only other thing I can think of is presiding over those naturalization ceremonies is one of the most rewarding things I do as a judge, because those people, after they take the oath of citizenship, they are glowing with pride to become citizens of this country, and it's something that you can tell it's been a life accomplishment for them. It's extremely rewarding to share that experience with them.
Thank you for sharing that with us. Judge Park, I'm going to ask you a hard question. You served as public defender for 20 years, I believe?
That's correct.
And I've taken a look at some of the cases that you were called on to defend criminal defendants before the court. Some of the crimes that were charged were absolutely horrible against those defendants. What did you view as your responsibility as a public defender and as an attorney when it came to the defense of these individuals?
Senator, I felt that it was my responsibility pursuant to the 6th Amendment of the Constitution to provide these individuals with zealous representation. That is what the Constitution demands, and that is what I provided to these individuals. So many individuals who come into the criminal justice system don't have an understanding of the crime that they've committed, the impact. And so throughout my career, I worked on many cases, as you've acknowledged, and throughout that process, advocated for those individuals, but also understood the impact that their offense had on others, and tried to acknowledge that when we were dealing with the case.
Judge Kasabai, I hope I get your name correct before the end of the hearing. Am I close?
Senator, it's Kasubai, and yes, you are right on.
I looked at your record. It looks like 4 years or so, maybe 5 as magistrate, another 11 or 12 as a state court judge, and you come here today. Can you tell me about the nature of a courtroom? Many people's experience is limited to what they've seen on television, and having practiced before being elected to Congress in the Central District of Illinois and getting to know the federal judges, I know the temperament of the judge and the environment of the courtroom itself has such an impact on whether people feel that they're being treated justly and fairly. What is your experience?
Senator, over the 16 years that I've had the privilege of serving as a judge in both the state of Oregon and in our District Court of Oregon, temperament and demeanor, particularly from the judge, but that also extends to the way in which our staffs engage with the people that come into our courtroom, absolutely impact how access to the courts might really turn into actually accessing the courts. So it turns the potential into the reality. The foundation of that is humility. and frankly, humility is the foundation of all things that come from the court and upholding the rule of law. And so what I try to do when I sit on the bench is to ensure that I extend to people graciousness and patience, so they have not just the opportunity to be heard, but to be deeply heard, for their cases to be considered. And when I issue a ruling, whether somebody prevails or doesn't prevail, I want that ruling to be conveyed in a way that helps them to think of the court as a place in which decisions can be decided impartially, without regard to who they are, and that they were heard.
First man I ever worked for in politics said humility is the first casualty in politics, and maybe that's the case. I hope that our deportment on this side of the panel will be excellent today as well. Senator Graham.
Thank you, Mr. Chair. Mr. Kazabai, in 2020, while you were a magistrate judge, you apparently gave a speech stating that Ibram Kendi is an amazing historian and author, and he does important work in the history of the construction of race. You wrote a book, am I right, called How to Be an Anti-Racist?
Senator, I want to make sure I understood the question. I didn't write a book.
Article? What was it?
I believe the author, Ibram Kendi, wrote a book about how to be an anti-racist.
Okay, I'm sorry, yeah. So you cite him in this speech, and here's what he argues, that the only remedy to past discrimination is present discrimination. The only remedy to present discrimination is future discrimination. Do you agree with that?
Senator, discrimination in the treatment of treating anyone negatively is not appropriate, and our courts, through the Student for Fair Admissions, has also clarified that as a national guidepost.
So you don't agree with that?
The statement that you meet discrimination with discrimination is not part of what our courts should be upholding. It has been clear in our guidance from the Supreme Court as well.
So you do not agree with Mr. Kendi's proposition as I read it to you?
That is correct.
Okay. Tell me about is it a pamphlet of your court? I think you created Pronouns in the Court Guide. Tell me about that.
I developed what's often called sort of a cheat sheet for the bench of just the simple prescriptions or language that I could use to ensure access to the courts, that everybody who comes before the court can be acknowledged and identified in dignified ways, and that related to the issue of the use of pronouns and honorifics, such as Mr. or Miss or Mix, and for that matter, Mrs. And so I invite people, when they come to court and introduce themselves, to offer their identity in the way of their honorifics.
Is that practice used by other judges, or do you know?
I know that other judges identify their pronouns, for example, in their signature emails, and that other judges throughout the state in Oregon encourage people to identify their pronouns when coming into court, so they also can ensure that people are dignified by identifying themselves in the courtroom.
I can't say the name of I guess it's the plaintiff here. Somebody versus the city of Eugene. Are you familiar with that case? Boudjerada.
Boudjerada.
Yeah. That case, did that case come before you? Did you rule that Eugene, Oregon's citywide curfew in response to rioting and looting and acts of violence was unconstitutional?
Senator, under the First Amendment, and that was the structure and the analysis in that case, involved a time, place, and manner restriction on protests.
Do you think you appropriately applied existing precedent of Oregon law to this case?
In every instance, Senator, I strive to apply binding precedent from the Ninth Circuit as well as the Supreme Court.
Well, this one to me seems like legal gymnastics to get around the most recent case in Oregon, but that's just my opinion. Further, along. In this same case, you recently ruled, I think, Eugene's city manager and police chief are not entitled to qualified immunity regarding their decision to implement the curfew. Is that correct?
In that follow-up opinion, after analyzing the issues of First Amendment and the time, place, and manner restrictions, I subsequently considered the issues with respect to several 1983 claims against individual officers, as well as the chief of police and the city manager. In that opinion, I found that the individual officers were not subject to suit because of qualified immunity. But
Well, I didn't ask you that. I asked you about the police chief.
And with respect to the police chief and the city manager, with the actions that were taken in light of what I determined to be a clear violation of a constitutional right.
One last question. How would you describe the violence and the destruction of property in Eugene, Oregon? How would you describe that?
Senator, violence and destruction of property anywhere
Would you consider it a riot?
Senator, the facts before me were involving the issues of whether the citywide curfew, as opposed to a curfew within narrow boundaries, was constitutionally appropriate.
I would encourage my colleagues to look at this particular scenario and make your own decision whether or not a curfew was justified. Thank you.
Thank you, Senator Graham. Senator Whitehouse.
Good morning, everyone. Congratulations on your nomination. I wish you well going forward. I was glad to see so many colleagues speak so highly of each of you. I've been watching our court in Rhode Island and also courts around the country witnessing a very significant diminution in civil jury trials. Jury trials generally, civil jury trials in particular. Some years ago, the then chief judge of our Rhode Island District Court noted that they hadn't seen a civil jury trial in 3 years. Now, with the appointments that we've made to that court, it has opened back up, if you will, and now civil jury trials are happening again. But civil jury trials have been, I think, considerably discouraged by actions of the Supreme Court as it relates to rules of procedure, and even more discouraged by the Supreme Court as it relates to agreements to handle matters through private mediation and arbitration, very often forced on consumers in massive contracts that they have no ability to negotiate. So I'm interested in hearing your thoughts on the role of the civil jury. I think our founding fathers saw it as not just a fact-finding adjunct to a judge, but actually an important part of our constitutional structure of governance. And in particular, those of you who've been magistrates, in some cases, it's the magistrate's job to try to make sure a case does not go to trial and to put pressure on parties to settle so that the judge doesn't have to go through running a jury trial. And I want to make sure that that's not the way you behave, and that's not the way you would behave as a judge. And I guess I'll just go right down the line, if you don't mind saying a quick word on your view of upholding the institution of jury trials should you be confirmed. Judge Cassaway.
Senator, jury trials are enshrined in our Constitution within the body itself and the 6th and 7th Amendments. With respect to civil jury trials, they're a cornerstone to our democracy. When Senator Merkley described a comment that I made about democracy works and only works when you shine the light on it, the juries are what bear witness to that which happens in our courtrooms and that which is determined to be fact or not. They are an incredible moderator to that which is and which is not. And without the jury system to help set that tone, to set that model going forward, we lose a piece of our democracy.
Senator, It's different. I understand your question to focus on jury trials and civil cases. There's a few things about that. I presided over my first jury trial as a judge within a few months of taking the bench as a magistrate judge. I do strongly believe in civil cases and the parties' right to have their cases heard and have their issues aired in front of a jury. As a lawyer, of course, that comes from my background of being primarily a civil trial lawyer, and so I've believed in the right to get to a jury and to try cases. And it is, as I tell the jurors in the cases when we're doing jury selection, that they're being there, they're participating in a fundamental right under our Constitution. They're participating in the Constitution. They're exercising their constitutional rights by participating. So I do believe it's a very important right.
Most of my experience has been in the criminal jury trial system. However, I will share this. It is vital to our justice system to have jury trials. I have had the pleasure of talking with jurors after the conclusion of their cases to ask them about their experience. And while many are very honest and say they didn't, coming in, they didn't necessarily want to serve, by the end of the trial, they were all honored to serve their country and to do their duty. And they recognize the importance of that process, to be a jury of their peers to an individual who has been charged with an offense. So I've recognized and see how vital jury trials are. And I would say in the state of Hawaii, civil jury trials are happening all the time. So it's alive and well there.
Mr. Semper, you'll be the last because my time is just run out.
Thank you, Senator. I share the views of my colleagues. As a lawyer, I've spent a considerable amount of my time in front of juries, putting important and difficult questions in front of them. I think the jury system is an indispensable feature of our legal system. And if I were so fortunate enough to be confirmed, I would certainly do what I could to facilitate the jury trial process.
Thank you, Chairman.
Thanks, Senator Whitehouse. Senator Cornyn.
Judge Kazin, I'm glad that the chairman asked you about your experience with naturalization ceremonies. My experience has been the same. It's one of the most positive, hopeful experiences that I've ever had, like you suggested, participating in that process. Of course, what we're talking about is legal immigration, which I think has been an important part of the lifeblood of our country, our culture, and our prosperity. Illegal immigration has been a disaster. You are going to be sitting as a Article III district judge in a border city, Laredo, Texas, right across the border, Nuevo Laredo, where when I was in college, we used to go over to dine and shop and things like that. No one goes to Nuevo Laredo anymore because of the violence and the kidnappings and the like. But can you just describe a little bit of the changes that you've seen in Laredo, a border city in Texas, over the last few years when it comes in terms of the volume of migrants, the drugs, and the violence?
Senator, of course, I've grown up and lived along the border my entire life. I raised my daughter in Laredo, Texas, and so we're part of the community. Illegal immigration is a serious problem for the border communities and the nation in general. We see, of course, a heavy volume of immigration criminal cases in our courts. That makes up the majority of the cases that we deal with. I don't personally, honestly, in my day-to-day life living in Laredo, I haven't experienced a particular change as a result of the immigration issues and the illegal immigration, but certainly it is reflected in the volume of cases that we deal with. Even as a magistrate judge, I handle a lot of different pieces of those criminal cases, and it is a serious issue that we deal with.
Senator Whitehouse talked about the dearth of civil jury trials. Have the immigration docket in border courts like yours made it difficult to get to civil jury trials because of the volume of cases?
Historically, that is exactly correct. Traditionally over the years, it was my father as a judge. As we know, we have deadlines to resolve civil cases, and so it's been we say at the courthouses, the criminal docket is a jealous mistress, and it is difficult to focus attention on the civil docket seriously because of the heavy criminal docket that we have along the border. And so one of the things I was told by my district judges that I was hired to do as a magistrate judge was to focus attention, because of my background experience with civil litigation, was to focus attention on the civil docket and try and get civil cases to trial if the parties consented to me.
Of course, there's probably no bigger impediment to access to the courts in a civil case than the cost of hiring counsel and the time it takes. And in fact, if you look at the statistics, I think one of the reasons why there's so few civil jury trials these days is because the cost of litigation. And I worry that more than anything else, that we've priced access to justice in a civil case out of the price range for most litigants, unless, of course, you happen to be catastrophically injured and are able to negotiate a contingent fee with the lawyer representing you, or perhaps you're hired by an insurance company or some Fortune 500 company. But that's a huge concern of mine, not something you all can necessarily solve, but I think it's a huge problem for our country in terms of access to justice. You might as well put the lock on the front door of the courthouse for many people, because they just can't afford to get there, or the time it takes to get their case resolved. Judge Kusabai, if I'm pronouncing that correctly, let me just ask you, Senator Graham asked you about some comments in a Oregon State Bar Bulletin, I believe, entitled, "Is There a Place for Us?" You stated that we must set aside conventional ideas of proof when we're dealing with the interpersonal work of equity, diversity, and inclusion. And in that same interview, you said, "As a judge, I can appreciate the challenge of employing a different mode for understanding truth." Could you explain what you meant by those words?
Yes, Senator. First, I'd like to explain that in the course of all of the time that I've served on the courts, that the rules of evidence, the burdens of proof, the standards that have been established by the law and precedent have always been that which I have followed and upheld.
Well, that's reassuring, but you can understand why I would ask a question about different modes for understanding the truth and setting aside conventional ideas of proof. Are you talking about in the courtroom or outside of the courtroom?
Absolutely not in the courtroom. What I was referring to was the idea of sitting down and talking with a friend from a different background. And when that friend from a different background might explain an experience, to be able to simply set aside the idea of saying, well, prove it to me, but simply accept that that was that friend's experience, to understand where that friend was coming from. So oftentimes lawyers could be accused of always trying a case, no matter who they might be talking to, including friends. And so the idea of setting that normal skill and technique aside when talking with somebody, whether it be at a coffee shop or even in a meeting, to be able to look at each other with dignity and understand that people have different experiences.
Thank you. My time's up.
Thanks, Senator Cornyn. Senator Blumenthal.
Thanks, Mr. Chairman. Thank you all for your service to your states and our nation, and I'm really impressed by the distinction of your backgrounds and your determination to continue careers of public service. Thank you and congratulations. Mr. Smith, I'm going to give you an opportunity to continue the response to Senator Whitehouse's question, because he didn't have time to finish, and it's an important question if you have anything to add.
Thank you, Senator. I appreciate the question and the opportunity to comment on it. The founding generation recognized the importance of the civil jury trial right. It was enshrined in the Seventh Amendment. I do think it's one of the bulwarks of our legal justice system. One of the things I would say is both the federal rules of civil procedure and, in slightly different language, the federal rules of evidence recognize that it is important for judges not just to ensure the just disposition of cases, but also the speedy and, to the extent possible, inexpensive disposition of cases. And I do think that judges have a role in trying to help move cases along so that it can be possible for some parties to try their cases, because civil jury trials, like criminal jury trials, are very important, not just for ensuring just results, but also for giving citizens and members of the community an opportunity to participate in that process.
Great. I noticed that you clerked for Judge Guido Calabresi and then for Justice Souter, two members of the federal bench I know well. Guido Calabresi has been a longtime friend in Connecticut, and then worked for the U.S. Attorney's Office in the Southern District of New York, and then went to Hawaii. How did you happen to go to Hawaii?
Thank you, Senator. I really appreciate the question. My wife and I both grew up in Hawaii, and we'd always known that we wanted to move back home at some point. I had been working in the Southern District of New York for about 6.5 years. And in the summer of 2018, my son, my oldest child, was getting ready to start kindergarten. And when we got to that point, we were thinking about what kind of education, what kind of upbringing we wanted him to have. And obviously, upbringing is great everywhere. But for us, having grown up in Hawaii, a particularly special place for us, we wanted our children to grow up there. So that was one of the reasons why that was the time period where we decided to move.
Well, Hawaii's gain was our loss on the East Coast, but congratulations.
Thank you, Senator.
Mr. Semper, you have extraordinary experience as a prosecutor, and now as deputy head of the criminal division in the U.S. Attorney's Office in New Jersey. I note that you were the lead prosecutor in the first homicide prosecution under New Jersey's domestic terrorism statute, if I have that correctly.
That's correct, Senator.
Maybe you can impart to us some of the lessons of that prosecution and how we should be mindful of the need either for strengthening our laws or in some ways reforming them so as to focus on domestic terrorism, which I view as the most persistent and lethal threat to our internal security right now.
Thank you, Senator. In that particular case, the defendant was radicalized online. During the time of the incident, he had sought after a lot of material related to ISIS, and his ultimate goal was to go to Syria to join the caliphate. During that radicalization process, he killed 3 men in his native state of Washington before coming to New Jersey, which he was going to use as a jump-off place to go to the Middle East. Before he ultimately took the life of the victim in our case. The lessons that I learned in that particular matter was, one, it was a collective effort by law enforcement. We were very fortunate enough to have an intelligence sharing apparatus between the local authorities in Washington, the federal agencies who we worked with, and also our local authorities in New Jersey. I have found generally in my experience with law enforcement that there is no I in team, and collaboration is really key to identifying threats and neutralizing them. As far as the rest of it, the policy stuff, I would leave to you all, the experts. But certainly it was a case unlike others I had dealt with up to that point.
Thank you. My time has expired, but I wish all of you well. You're going to be great judges, and you will be the face and voice of justice for most litigants who can't afford to take appeals, as you well know. And I would just add my voice to others who talked about the immigration naturalization proceedings, which I do regularly. I'm going to be doing them this Friday in Connecticut. I love doing them. They give me hope and inspiration, especially as I get out of Washington from time to time. Thank you.
Thanks, Senator Blumenthal. Senator Lee.
Thank you, Mr. Chairman. Thanks to all of you for being here and for your willingness to be considered for these important positions. Judge Kasuba, I'd like to start with you, if that's all right. A few months ago, in May of this year, you gave a presentation to the Oregon State Bar in which you included the following in your remarks. Quote, DEI, diversity, equity, and inclusion, is the heart and soul of the court system. Can we say that? Yeah, I just did, and I say it proudly. Mr. Kasuba, Judge, could you explain what that means?
Yes. access to justice is at the heart of the work that I do within the courtroom, and ensuring that everybody is dignified and treated with dignity when they come into the courtroom, and for me to preside over those cases.
But you'd say that's the heart and soul of the judicial system, more than equal justice under the law, more than the Constitution, more than the law itself, or the job of interpreting the law fairly, where litigants before you have disagreements as to the law's meaning.
In the way in which, and in the context in which I was using the term and referring to diversity, was the idea and the ideal of equal justice under the law. That everybody, no matter what their background, beliefs, whatever that might be, that everyone is entitled to access to the courts and that equity.
All right, let's circle back to that one in a minute. The First Amendment's protection of free speech is foundational. It's been described as one of our first freedoms. It's been described accurately, I think, fairly, by many as being upstream from all of our other rights. And it has to be protected vigorously. And we also know that there are time, place, and manner accommodations that can go along with that. Among other things, there are special exceptions that occur where riot control measures are necessary due to an outbreak of coordinated, overt violence. In a case that's been referred to briefly in the hearing today, but not much, this Bucciarati versus City of Eugene, you're dealing with some interesting circumstances. You had riots taking place. There were 3 nights of terror in Eugene, Oregon, during the BLM riots of 2020, where, in your words, the following was going on. Quote, a crowd applying graffiti, lighting fireworks, and blocking traffic, throwing glass bottles towards officers surrounding a patrol car, smashing its windows and puncturing its tires, with the officers inside the patrol car, mind you. The group, quote, started fires in the roadway, attacked people and vehicles in the downtown area. Several businesses were vandalized and looted, and several officers were injured. You went on to state that members of the group carried heavy backpacks and bottles and were communicating via radios. So in response to this, the city implemented some riot control measures. They imposed a citywide curfew, one that lasted 7 hours. We had 3 rioters who were arrested during the curfew, and despite the Ninth Circuit precedent in the Mariotti case, the Minotti case, addressing a very similar curfew in Seattle, you decided that the Eugene, Oregon curfew was unconstitutional. Can you explain to me how, consistent with the Ninth Circuit precedent in the Minotti case, how does a 7-hour curfew through the middle of the night in the wave of such destruction and terror prevent ample means of communication? Can you explain that to me?
The Minotti case did provide guidance and assisted me in evaluating the legal analysis that I applied. There were 2 curfews that had been imposed. One was a downtown curfew, so there were geographic restrictions. That was not the curfew that was before me, nor did I find that unconstitutional. It was a citywide curfew that actually subjected everybody in the city, well beyond the boundaries of downtown, to out into the residential neighborhood, such that the application of that curfew, that citywide curfew, could have criminalized people's behavior of just trying to get home, well outside of any of the riots and the protests.
You've praised Ibram X. Kendi as someone who you like. He's an amazing historian and author, and you said that you would like to push some of Ibram X. Kendi's ideas even further. I'm sure you're aware he's famous for saying, quote, the only remedy to racist discrimination is anti-racist discrimination. The only remedy to past discrimination is present discrimination. The only remedy to present discrimination is future discrimination. Kendi also stated that in order to truly be an anti-racist, you have to be anti-capitalist. So I'd like to know, first of all, what would you do to push Ibram Kendi's ideas even further? And do you believe someone should be praising, someone who is currently a federal magistrate judge, be praising someone who encourages discrimination in any circumstance?
Senator, I don't recall having ever remarked that I want to push Ibrahim Kendi's ideas further. In questions earlier in this hearing, I clearly stated that the ideas that have been described here that have been attributed to Ibrahim Kendi are not ideas that are consistent with the 20 years in my public service, 16 as a judge, and the record that I have shown striving to apply the law, the Constitution, and Supreme Court precedent would not be consistent with this idea of supporting the ideas that you've described as Ibrahim Kendi's.
So you're saying that you have never said that you would like to push some of Ibrahim Kendi's ideas further?
So I don't recall having made that particular statement.
Okay. I see my time has expired. We'll follow up on these in writing. These are concerning one of the most fundamental laws we have that's embedded within our Constitution, is that governments can't treat people differently on the basis of their race, and that's why this is important to ask about. Thank you.
Judge Kostabai, this case, Gujarata case, has come up several times. Can you tell me, was that subject to review by the district court? How did they view your ruling?
That was a case in which the parties had not consented, and it was reviewed by a district judge and adopted without opinion on the issue of the constitutionality finding with respect to the curfew. The follow-up finding and recommendation is still before the district judge and is on review.
I see. Senator Hirono.
Thank you, Mr. Chairman. Congratulations to each of you. To ensure the fitness of nominees before any of the committees on which I sit, I ask the following two initial questions, so we will just go right down the line, starting with Judge Kasabai. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator.
No, Senator.
No, Senator.
No, Senator.
No, Senator.
Have you ever faced discipline or entered into a settlement relating to this kind of conduct?
No, Senator.
No, Senator.
No, Senator.
No, Senator.
No, Senator.
For Judge Park, you spent the majority of your career working in the Office of the Public Defender for Hawaii. Public defenders play a vital role in the justice system by ensuring that all defendants, regardless of means, have their constitutional rights to counsel. Can you speak briefly to the importance of having strong prosecutors and defense attorneys in our adversarial justice system?
Thank you, Senator. The Sixth Amendment requires that there is a right to counsel, and the reason why that is so that there can be a balance of power with respect to these cases. Individuals who are charged with an offense are simply charged. The government has the burden of proof, and to prove that charge beyond a reasonable doubt. And it is necessary to have attorneys represent these individuals in order to hold the government to that high burden of proof that is required under the law. And so that is something that I did for 20 years. And I find that the right to counsel pursuant to the Sixth Amendment is vital in order to have a fair and just legal system.
For both you and Mr. Smith, parents can have a profound impact on our lives. Mr. Smith, your father immigrated to this country from Honduras. After completing seminary, he worked his way through college as a janitor and went on to earn a doctorate and become a professor. Judge Park, your father spent a long career on the Honolulu Police Force, rising to the rank of major and serving as president of the Police Officers Union. For both of you, how have your parents' experiences impacted your lives and your careers? And this includes your mother's, although I just mentioned your father's. Go ahead, Judge Park.
I had the honor of witnessing my father work hard as a Honolulu police officer. His example of public service is what drives me to this day. Growing up, I used to paddle canoe and didn't want to catch the bus home after being wet for so long, and would go to the Honolulu Police Department and sit until my father was ready to come home. But he was so dedicated to his job and doing the investigations that he did inspired me. And so he was vital to my decision to enter into the law. And my mom's support of him throughout his legal career was critical. My dad would not have been able to do the level of police work that he did without her love and support.
And he would agree with that.
And he would agree with that.
Mr. Smith.
Thank you, Senator. When you're fortunate, as Judge Park and I were, to have the kinds of parents we did, your parents help you see what's possible. Just watching their life stories, the things that they were able to do from where they started and where they ended up, makes it possible for their children to think the same thing. And I know that my siblings and I all feel that way. Since my father was already discussed a little bit, let me say just a few things about my mother. My mother became a Head Start teacher, a substitute teacher in public school. I remember having her in one of my classes at least once. And as a kid, that's always embarrassing. In the summers, she would sometimes work shifts at Kmart to help pay the bills. And I think when you see parents just dedicating themselves to helping their families do well, it teaches you those values.
In the brief time that I have left, again for both of you, Judge Park and Mr. Smith, Judge Park, you would be the first Native Hawaiian woman to serve in the federal district court. Mr. Smith, your father, as I said, is an immigrant from Honduras, and your mother is of Japanese ancestry. In my view, the judiciary should reflect the diversity of our nation, and both of you reflect the vibrant diversity of Hawaii. Could you just very briefly talk about why diversity is so important, as I assume it is important to each of you?
I think diversity is important, both personal and professional diversity on the bench, because a diverse bench represents the community that it serves. And when you have a diverse bench, it builds and brings integrity to the institution. And so I think it is very important.
Mr. Smith?
Thank you, Senator. I think diversity in its broadest sense is very important. And I do agree with Judge Park that when the community sees that the bench in all positions of public importance are open to everyone from all sorts of walks of life, backgrounds, perspectives, it promotes and ensures trust in those institutions.
Thank you, Mr. Chairman.
Thank you, Senator Hirono. Senator Kennedy.
Thank you, Mr. Chairman. Judge Kasubai, I'm looking at an order you issued as a magistrate judge here requiring the use of pronouns in your court. Do you require the use of pronouns, the declaration of one's pronouns in your court?
Senator, that may be referring to perhaps a trial management order or a scheduling order of some kind?
Yeah. No, it's a statement. You issued it. Here it is.
It's an invitation for people to identify their pronouns and or their honorifics.
Well, I'm looking at your requirement that you issued to all people in your court. You say, quote, when you introduce yourself in a meeting, you should say, my name is Judge Blank and my pronouns are blank. Is that right?
Senator, those were not requirements or rules. Those were suggestions and
That was suggestions.
Those were suggestions and invitations for people to use.
And you also, in your directive, you say, quote, I'd like counsel to introduce themselves giving your full name and your honorific, such as Ms., MS period, Mix, or Mr., not Mrs. And if your client will be making an appearance, I ask you to please introduce them to the court by giving me their full name and their honorific, such as Ms., MS period, Mix, or Mr. End quote. Is that right?
Senator, it's not a directive. Again, it's an invitation for people to introduce themselves.
Invitation. Yeah. Okay. All right. I'm looking at an article from the Oregon State Bar Bulletin from May of 2021. And I want to read one of your quotes. Quote, we have to set aside conventional ideas of proof. Let me say that again. We have to set aside conventional ideas of proof, you said, when we are dealing with the personal and interpersonal work of equity, division, and inclusion. As a judge, I can appreciate the challenge of employing a different mode for understanding truth than that which most lawyers are accustomed to in our work, end quote. Did you write that?
That is a quote from that article.
So when we're dealing with equity, diversity, and inclusion, we should set aside conventional ideas of proof. Is that right?
In the larger context of interpersonal and personal relationships, the idea of being able to have a conversation with somebody.
Yeah, but you didn't talk about a conversation. You said proof.
It's in the context of having a conversation with somebody about the issue of their background and their experience.
So when the issue is equity, diversity, or inclusion, we should have a different set of proof. Is that right?
When it comes to the space in which people have interpersonal relationships with one another, the idea of respecting and dignifying each other with their experiences is an important part of...
So all issues have one set of proof, which has been handed down by our state Supreme Courts, our U.S. Supreme Court, except you think we ought to have a different set of proof when equity, diversity, and inclusion are at issue. Is that right?
In all of my years on the bench, Senator, I have applied the law, the rules of evidence, the case precedent.
Let me move on. I'm looking at the notes you gave us from a speech you made in February 7, 2020. It's entitled Speech Reflections on Equity and Privilege to the Oregon Blacks in Government. You wrote, quote, "White, male, straight people allow privilege to remain in place," close quote. Did you say that? Did you write that?
Without looking at the specific speech
here. You turned it in.
Well, if that's on the piece of paper, Senator, then I have no reason to disagree.
You also wrote, quote, "Privilege is incredibly similar to narcissistic personality disorder," close quote. Did you write that?
Without looking at everything in the context of that statement, it appears correct.
Okay. You wrote, quote, "The identity of Muslims also need to be normalized in a country that is so deeply Islamophobic." Did you write that?
Senator, I did. And what I'd also like to clarify is that in the context of my work on the bench, I have treated everybody equally without regard to their background.
Sorry, I just want to get through this. I'm going to run out of time. You also wrote, quote, "I am disappointed about the way in which the founding fathers of this country perpetuated inequity," close quote. Did you write that?
In the context of the issue of slavery, that was something that I'd been considering.
In your notes you gave us from a speech on May 17, 2023, "Does race matter?" You said, quote, "Does race matter? Hell yes," close quote. You know that T-shirt at the Saturday markets, the one that says something like "Love, see no color," and it has all the colors of the rainbow all over it, and it's like a tie-dye shirt. Well, the first time I saw it, I said, how sweet. Then I got angry. If love doesn't see color, then I don't have allies, close quote. Did you say that?
Yes, and that was to explain that the work of equity is to help understand where people are coming from, not to ignore who they are.
And you also... Yeah, no, I'm sorry. Can I have 30 more seconds? Judge, you seem to be obsessed with race and sexuality. I mean, you even go so far as to say that when race and sexuality and diversity and inclusion are at issue, we need a separate standard of proof in the United States federal judiciary. How are litigants going to be able to trust you?
Senator, that's not what I've said. There is no different standard.
It's bigger than Dallas. I read it to you.
When you
turned in these documents. I didn't go looking for them.
When
you
you look
seem proud of it.
as anyone who reviews my record on the bench,
I have
thousands of cases.
I'm going to let you finish responding, and your time has expired, but go ahead.
The rule of law is an absolute for me. The work that I have done on the bench over the last 16
That's not what you say.
The work that I've done on the bench.
But that's not what you say.
Judge, finish your sentence.
The work that I've done on the bench in ruling over all the people's cases that have appeared in front of me from all backgrounds, of all faiths, you'll find that I have upheld the rule of law and upheld the precedent of our Constitution and our Supreme Court and the Ninth Circuit.
Well, if the chairman would give me time, I could go through the cases and prove that that's not the case.
Senator
I just don't see how you can be a fair-minded judge.
Senator Booker.
Thank you very much. Mr. Kasubai, my favorite author is James Baldwin. Would you love his books, quote from his books? Would you make the presumption that I agree with everything James Baldwin has said?
I wouldn't presume that, Senator.
I read my colleague J.D. Vance's book, Hillbilly Elegy. I have bought it for other people. Would you think and ascribe to me all the views of my colleague J.D. Vance?
No, sir.
I have a little, forgive me, this is a little petty, I'm about to do this, but I have bought Senator Cotton's book. I bought it because he didn't give it to me. That's the petty part, I apologize. It's actually
I'll still sign it for you, though, if you want to.
But it is actually pretty extraordinary. Senator Cotton surprised me. He's quite a historian. Would you ascribe to me all the views of Senator Cotton?
No, sir.
Even if I've quoted from his book.
But you should.
Even if I've quoted from his book, would you do that?
I would not, sir.
So the book that's been brought up, How to Be an Anti-Racist, which was on Time Magazine's must-read list, which was a runaway best-selling book, would it be a mistake for anybody to ascribe to you all the views of the author?
It would.
Yeah, absolutely. I agree. There's some points in the book that are worth quoting, and I don't remember, but I imagine I may have. But there are definitely parts of the book that I don't agree with as well, and that's the same for you.
It is correct, sir.
Does my race matter?
Without going into a couple of hours of a conversation, Senator, it depends on both the person as well as how people perceive them.
But isn't that the point? Like, what a crazy question. My race doesn't matter. It's such a hotbed of discussion in America now. It's often very polarizing. But the truth of the matter is, it's part of my identity. I'm a Christian. I'm an American. I'm a black guy. And to me, obviously, those are identifying features that matter. Within the criminal justice system, would it be fair to have a judiciary that did not have African Americans?
It's important for diversity to be represented on the bench. Experience is the life of the law.
Right, because the law is independent in many ways, should be, I should say, independent of racial reasoning when applying the facts of the law, right?
Correct.
But I've seen lots of studies, you don't need to comment on, about implicit racial bias in the law. We know from the data that if you control for other factors, income, geography, education, that African Americans in the criminal justice system have tended to get longer sentences for similar crimes. Are you aware of that research?
I'm aware of that research.
Right, and so the idea that diversity is important to talk about, to have a criminal justice system that reflects the diversity of the population. Many people, even if it's just for the matter of faith in the system of minority groups, one would say that diversity is very important, yes?
Absolutely.
But I think there's at least a spirit that I'm feeling that your views on the importance of diversity, the urgency, I would say, of diversity, that you're understanding that the legitimacy of the courts, you're understanding that everybody from Harvard Business School to consulting companies like McKinsey have said diverse teams are better teams. There's some kind of confusion with perhaps those strong beliefs and your ability to be an objective judge in legal matters and to apply the law. And I would just like to ask you, when it comes to the cases that come before you, what is the process by which you go about to coming to conclusions?
Senator, it's a very stringent and rigorous process. It starts with reading the briefs and then reading them again and making sure I understand the issues that have been raised before me, the law that is being applied and invoked by the parties, and then working through each and every one of those arguments and understanding the rules that are being invoked and testing the hypotheses that the parties are making in their arguments over and over and over again.
And so I don't need to go through the rigorous processes, but you don't care what their pronouns are when you're applying the law.
Absolutely not.
You don't care the color of their skin when you're applying the law.
Most certainly not.
Yeah, you are applying the law, even though you do believe, like most of the people around this dais, that having diverse teams is a good thing for America. When it comes to doing your job, you have a rigorous processes of which these things don't enter.
You said it better than I could, Senator.
Thank you very much. The last thing I just want to say is to Jamal Semper, your mother is extraordinary. Is that true or false? That is a trick question.
Senator,
you're under oath, yes.
Senator, before God and country, my mother is quite extraordinary.
She is an immigrant to this country, yes?
Yes, she is.
She has two extraordinary children, from my understanding, right?
She does.
You and your brother.
Yes.
Your brother got cancer in his 9/11 related heroism, yes?
Yes, he is.
Yes.
Yes, he has.
And he has been supportive of you because he's the older brother, right?
Yes, he and my mother helped put me through law school. I'm incredibly grateful for them.
Right. So you will do right by this country should you get this position?
Senator, if I am fortunate enough to be confirmed for this position, I will do all that I can to serve.
And you will do right by your mama, right?
I have and I will.
Thank you very much, Mr. Chairman.
Thank you.
Senator Blackburn.
Thank you, Mr. Chairman, and congratulations to each of you on your nominations. And it's so wonderful to hear your introductions of your families. And I'm so pleased, Mr. Kimber, that you now have a congressional edict to be good to your mama. I think that is just awesome. We mamas like things like that. We're also informed by looking at your records and reading your writings. And Judge Cassaba, I want to come to you because as I looked at some of your readings and writings, your decisions, you seem to have an affinity for Marxism. And in a 1994 essay, you criticize the concept of private property, and I'm going to quote you here. You argued that, and I quote, property incites rebellion, end quote. And this is one of the many positive statements that you have made about Marxist approaches and Marxist policies, Marxism, and you know, President Reagan, as I was reading some of your things that leaned toward Marxism, I thought of President Reagan's comments when he said that the March of Freedom and Democracy would leave Marxism on the ash heap of history, and that's exactly where it belongs, because Marxist regimes, as of 2023, have been responsible for the deaths of over 100 million people. So it disturbs me when I see this leaning to Marxism in your writings. So a yes or no question. Are you a Marxist?
No, Senator.
Okay. Will you right now disavow the tenets of Marxism that you have praised in some of your writings?
Senator, I have not praised Marxist ideas, and I would disavow any other system than that which is than that would be supported by our U.S. Constitution and our laws.
I appreciate your comment, but sir, in your writings, you have given the opposite opinion. But you've also made a number of concerning statements regarding sexuality and the disempowerment of women. Specifically, you've aligned yourself philosophically with a professor who has espoused the disturbing views that all heterosexual relationships are per se infused with violence and that all sexual acts should be viewed as rape. Not only is this view wrong and offensive, but also, and perhaps more importantly, it undercuts the important work that is being done across this country to empower survivors of sexual assault. When you say that all sexual acts are rape, you delegitimize and silence women who actually are victims of sexual assault. So how can women possibly trust that they will be treated fairly in your courtroom given your disturbing views on this subject?
Senator, the law review article to which you're referring, I believe was published, I wrote in 1995. I did not align myself with those ideas. The law review article summarizes several different
We're
theories
familiar with the article. Do you regret citing these very concerning statements?
Senator, the description or summary of these different theories is not a subscription to or an attestation of the validity
Do you
of.
denounce the view that all women are per se disempowered by our system?
I do not ascribe to those theories that I was summarizing in that article. And I would also turn to my years of serving on the bench and treating all people fairly.
Let me move on. I've got 30 seconds. I also was troubled by your involvement as the prosecutor in the Gonzalez case. Mr. Gonzalez was arrested for allegedly raping a 12-year-old little girl. The FBI eventually reviewed the media seized from his home and identified horrific images of child sexual abuse. The sentencing memo that you prepared, oh, this is for Mr. Smith. Your sentencing memo, you outlined Mr. Gonzalez's heinous crimes. The images that were found on his phone were created in his home, in his own bedroom, with girls as young as 10 years old, and they found out he had parties. He would offer them illicit substances. He would then abuse them, and he did this multiple times over a 15-year period of time. It started in 1997, and still with all of that information, you went far below the guidelines. And in fact, for this repeat child abuser, you recommended a sentence of just over 10 years. And he had done this to kids for 15 years. So why did you do that?
Thank you for the question, Senator. I do recall the case of Mr. Gonzalez. That was a case that I believe I was assigned when I had just started in the office. I recognized immediately the seriousness of those offenses, and I believe I had Mr. Gonzalez prosecuted within a month or so of my having been assigned the case. When I make sentencing recommendations in court, especially as a new prosecutor in the General Crimes Unit in the Southern District of New York, I make those sentencing recommendations.
Okay. Well, the court rejected your recommendation. They went above you to 15 years and then gave him an additional 10 years of probation. This is something that is terribly concerning to me. Thank you, Mr. Chairman.
I'm going to let Mr. Smith finish his answer to your inquiry.
Thank you, Chair Durbin. I just wanted to mention, particularly in the General Crimes Unit in the Southern District of New York, the sentencing recommendations that we make are in close consultation with our supervisors, considering all of the 3553A factors. And so when I appear in that forum, I'm representing the office. And I do that as a prosecutor in all of my cases. I am not speaking on behalf of my own personal views. I try to set those things aside, and I try to represent the office. If I were fortunate to be confirmed, I would do the same as a judge. I would set any personal views aside, and I would endeavor to apply the law faithfully and to find the facts fairly.
Thank you, Mr. Chair. Well, first of all, congratulations to each of you for the nomination and for the opportunity to be here today. In preparation, I'd be shocked if you haven't been advised that when it comes to be Senator Padilla's turn, here's a question to anticipate. Diversity is a beautiful thing. It's I think one of the biggest strengths of our nation, not just across the board, not just in communities, not just in government, but in particular the federal judiciary. I know my colleague Senator Horozo asked a general question about diversity. I always ask about diversity because diversity is important, not just in terms of who sits on the federal bench, right? The diversity of life experience, the diversity of professional experience ought to be part of the process and considered not just for more inclusive and reflective outcomes, but for public confidence in the federal judiciary and its decisions. All that being said, what I tend to ask nominees is, what would you do if you're fortunate enough to be confirmed to advance diversity in your courtroom? If you agree with my value statement, and if you disagree, I'd love to hear it. And not just broadly with support staff and whatnot, but particularly when it comes to law clerks. I think most of you may have a specific example or experience where a quality clerkship experience can really help a career at the outset, whether you pursue public service, whether you pursue private practice. That clerkship opportunity can be pivotal. So what can we do to open the door to that experience for a more diverse group of young law students and law clerks than we have historically? And we'll start with Mr. Kasaway.
Senator, I agree with your value statement. And with respect to the work on the court, it's absolutely important to bring diversity and diverse experiences from all backgrounds, not to staff. That's important, but law clerks, over the 16 years that I've served on the bench, I've worked hard to ensure that I have a diverse group of law clerks that have worked with me throughout all of these years. But we have to go further than that. It has to be externs, people from law school, students, and then reaching out into the community to high school and middle school to make sure that people are thinking about law school not just at the last minute, but their entire lives.
Thank you.
Senator, I agree that diversity is important. Over the last 5 years as a federal magistrate judge, I have hired law clerks from different geographic backgrounds, religions, genders, of course, law schools, and just national origin and race. But all those experiences, I believe, are important to enrich and give different perspectives on backgrounds. And so it is something that I'll continue to do with the law clerks that I hire.
I started my legal career as a law clerk to a magistrate judge, and I know the value that clerkship provided to me and the doors that it opened. When I look to hire not only law clerks, but interns and externs that help and assist in my chambers, I do look at not only their personal diversity, but their professional diversity. And that is important to me when I make that decision on who to hire.
Thank you, Senator. I agree with the comments of my colleagues. I think diversity is very important. I think it helps when you draw more people into our institutions, particularly institutions like the judicial system, I think that helps to affirm the confidence that the community must have in our institutions. I would also just say, I think academic diversity is important as well. I came from a state law school, and these positions, they are great and they are stocked with a lot of people from the top schools, but I think there's a lot of talent within our state schools. And so if I were fortunate enough to be confirmed for this position, I would have an eye towards that as well.
Thank you, Senator. I don't think I could say it better than my fellow nominees. I agree that diversity is important in its broadest sense. And I also agree that legal clerkships at the beginning, especially, really at any point in a nominee's career, are incredibly important. They were certainly important experiences for me. And I would be carefully trying to pick the best people for those positions, recognizing their importance.
Thank you very much. Mr. Chair, before I close, I just want to clarify that there's still an opportunity. The deadline for letters for the record, letters of support for these nominees is still open.
Yes.
So there's still time for Mr. Semper's mom to weigh in here, if necessary.
I'll do some lobbying. Thank you.
Senator Cruz.
Thank you, Mr. Chairman. Judge Katsubai, I think your fellow nominees owe you a debt of gratitude because many Biden nominees have been extreme, but your record is so far out of the mainstream that you have attracted virtually all of the questions. I was particularly intrigued by your statement to Senator Blackburn that you said you are not, in fact, a Marxist. And then you said, and I wrote it down, I have not praised Marxist ideas. Now, as you know, in law, there is the fact of evidence. And so let's go to something you wrote, an article that is entitled Centralized Property Theory, in which you wrote, it begins, it's on the front page of your law school newspaper. You write, quote, intimate knowing, the lovers kissed, familiar and ever exciting, passionate transcendence, beyond the physical exhilaration lies a burning light in our limbs, our hearts, floating, flying, falling in every direction, amorphous and wonderful, time-stretching, space-curving, exquisitely explosive eros, and yet I timidly tremble every time. Now, somehow this is about property, which is not immediately evident as to why, but later in the article you write, you say, property is not simply a relationship between an owner and an object of ownership. Property is primarily a complex relationship between people and secondarily regards the objects people exploit. Historically, three paradigms have dominated European notions of property. Locke appealed to the notion that labor points to who has the right to exploit property. Bentham relied on utility to dictate who has rights based on how the property is exploited. And Marx was plainly disgusted with the alienation that property imposed and its establishment of an us and them and haves and have-not. Each theory alone denies important components of human experience. Among them are the ability to work, the need for personal privacy and boundaries, and uniquely diverse desires which spin us all in differing life directions. However, the process towards integrating all three may provide a framework for relationships that enhances each unique self. The aspiration towards intimate knowing, the intimate knowing of oneself and others, is a creative struggle towards redefining property. What the hell does that mean?
Senator, when I was preparing and reviewing my materials for this hearing and for the process, I also have to admit that that writing was far from clear or articulate, and the poetry was definitely not good. Now, Senator, I don't make...
Do you believe we need to have a creative struggle towards redefining property, which is what you were advocating for?
That was something that I wrote 30 years ago, Senator, and in the course of just exploring law school and the ideas that came with...
Okay, so your flirtations with Marxism were 30 years ago, so let's go more recent. In 2020, you gave a speech entitled Reflections on Equity and Privilege, and you said, quote, first, the world is wide enough for all of us. Privilege derives its power from the belief in scarcity, scarcity of money, natural resources, food, and power itself. The desire to control it all drives privilege. I want to suggest to you that equity, the idea of equity, rejects this model of scarcity. Now, that's Marxism in 2020. What did that mean?
I've never considered that to be Marxist, Senator. It's the idea that equal access, and in the context of the work that I do here...
So there is no scarcity, there are no property rights. Equity gives everyone an entitlement to each other's property. Is that right?
Not at all. And in the context of the work that I do on the bench, Senator, when you look at my record for all of these 16 years, you will find that I have upheld the Constitution and our case precedent.
Okay, well, let's turn to something else you wrote in the Wisconsin Women Law Journal. Again, this is your writing. The name of the article is Destabilizing Power and Rape, Why Consent Theory and Rape Law Has Turned on Its Head. You cited Professor Catherine McKinnon, who argued, quote, sexuality itself is a power web in which heterosexual relations per se are infused with violence and control, and, quote, most intercourse is rape. Now, her views are extreme, and yet, and when Senator Blackburn asked you about them, here at the hearing, when you want to be confirmed, you try to distance yourself from them. But here's what you wrote in the article. You embrace those views. You wrote, quote, I employ the view that rape is sex in order to focus on the significance of consent in rape law. The Sex Act is a violation per se without consent. In order to properly align the consent doctrine in rape law with consent in other areas of law, non-consent must be presumed. Do you believe that is a mainstream view, that heterosexual sex is rape?
Senator, in that article, I was exploring different ideas and theories, and I was employing the hypothetical that you've just described to try to tease out a particular issue with respect to consent. With respect to your last question...
So you also quoted Professor McKinnon, who wrote, quote, "Sexuality is to feminism what work is to Marxism." Let me ask you again, what does that mean?
Senator, I was summarizing different theories that people were presenting, so that way I could explain them and then employ an analysis with respect to the issue of what consent was in the context of sexual assault back in 30 years ago.
I think your views are far, far out of the mainstream.
Senator Welch?
Thank you very much. I'm going to ask Judge Park. I'm a public defender. I think I'm the only one in the Senate, and I've been delighted at the number of public defenders who've been nominated. And our Constitution, of course, provides for the right of a zealous advocate for everyone charged with a crime, because it is about the process, not the individual. I just want to ask you if you agree, and I'm sure you do, about the necessity for zealous advocacy from the defense as well as from the prosecutors, and if so, why?
It is necessary in order to have a fair and just...
Is your microphone on?
It's necessary in order to have a fair and just criminal system, that there be zealous representation on both sides of the aisle. Not only does our Constitution require it, but the case law requires it. It requires that federal public defenders be effective.
Right, and that's the 1938 Supreme Court case, Johnson v. Zerbst, and the 1963 Supreme Court case, Gideon v. Wainwright, held that the Constitution requires appointment of counsel. Can you tell me whether, in your experience, we're living up to meeting that constitutional requirement?
The Federal Public Defender's Office that I worked at certainly did. There was time when I was there, the Federal Public Defender made sure to train the attorneys to be able to do our job and to do it zealously within the bounds of the law. And at that office, when I was there, I also participated in training other attorneys to do just that.
That's great. And my understanding, according to statistics, that 9 out of 10 defendants in federal court, U.S. District Court, have appointed counsel.
I would believe that number may be accurate, yes.
Well, that's why I'm definitely hoping, as I've said before, that we maintain the budget. We don't cut it for the federal defenders. Thank you.
Thank you.
Judge Kusaba, you know, my colleagues on the Republican side are asking us about some of your writing and what you mean, and whether it's clear or it isn't, whether it's prose or poetry. But I have a lot of respect for the academic inquiry into issues like what is property, how does it affect relationships. That's a normal area of legal inquiry, is it not? Whether people agree or not with what a particular writer says.
Senator Welch, I agree. In order for me to love the law and love our country, looking at things in a critical way just simply substantiates why our country and our democracy is as great as it is.
Right. But then when you are in your role as an academic where it's open inquiry, which is different than your role as a judge, which is confined by the boundaries of the law, and I heard in one of your earlier answers your description of the process you go through, reading the briefs, testing them, and the hypothesis. Can you just explain that and what you would be doing in your role as a judge as opposed to in your role as a, I would say, academic?
It is a profound obligation and duty to uphold the rule of law. End stop. And in the course of the work that I do, under the oath that I've taken as a magistrate judge in the District of Oregon, is to rigorously evaluate the law. If it's a jury trial, ensure that the rules of evidence are applied so the record can be complete and without question, and then to apply those facts to the law as necessary.
Thank you. And, you know, the question of diversity came up, and everyone of you answered that you're in favor of diversity, but I know among some of my colleagues, there's apprehension that diversity means special treatment. And I just want each of you to have an opportunity to say that, to indicate whether, if you have a defendant, diversity is going to determine or affect your decision about what the law says or requires. Any, yeah.
No.
No, Senator.
No, Senator.
No, Senator.
Okay.
No, Senator.
All right. Thank you very much, and congratulations on your nominations. I yield back, Mr. Chairman.
Thank you, Senator Welch, and I'll just make a couple observations. Judge Kosobai, 16 years on the bench, is that right?
16 years on the bench and 4 additional years as a neutral appellate adjudicator.
Did you ever write an opinion during that period of time?
On the bench, no. As a neutral adjudicator on the Workers' Compensation Board, I was involved in panel decision-making, and opinions had been issued.
When it came down to the cases that you considered as a state judge and a federal magistrate, there is a written record.
Yes, and you're right. State court, and as a magistrate judge, my written opinions, well over 400 of them are clear for the record.
And isn't it interesting today that when we've considered your life's work and whether you're prepared for the federal bench, the only reference made was to a case Bujarad, which you, I suppose, issued an opinion as a magistrate, which was accepted by the district court?
Correct.
So the only opinion out of the hundreds that you have written, the higher court said you were right on. Your view of the law, the First Amendment and such was appropriate. But they've gone back. If I could give counsel to any law school class and say to them, if you ever aspire to be a federal judge, hold some of those wild thoughts in your mind. And don't write them down so that some senator 30 years from now can read them back to you.
Especially poetry.
Yes.
Senator. Well,
Your poetry has been fed back to you today. And I'll just say that they didn't spend much time, in fact, literally no time, on written opinions involving the law and the facts, and went after your poetry. So don't be discouraged. Poetry is still very important. Well, it turns out that we have questions for the record will be due to the nominees by 5 p.m. on Wednesday, October 11th. The record will likewise remain open to that time to submit letters and similar materials. The hearing is going to stand adjourned with gratitude to the nominees, their families, and friends.